So you are now the host, Angelica.
Okay. Oh, yeah,
All
I see
right.
the dots and everything. Thank you.
Very well, so I'm leaving.
All right. Thanks, Anna.
All right, good morning, everyone. I'm
Morning.
Angelica Anaya Allen, the hearing examiner appointed to handle this matter. I certainly appreciate everyone appearing at such short notice, but particularly given the holidays and the hearing schedule that we have, I wanted to try to address these issues as quickly as possible. And I would add that probably led to my slightly premature issuance of the order of which the city of Las Cruces has complained, which was in fact issued prior to my receipt of their response brief. So my apologies to the city for jumping the gun a little bit there. So what we're on today is on the city's motion for reconsideration of that order. Denying the request for confidentiality determination. So we'll start with first, our court reporter had a question about whether or not there would be any request for an expedited transcript by any party.
Not from EPE.
Not from staff.
Not from the city. And I apologize. I'm realizing that being the shortest days of the year, the lighting in my room is wretched. I just tried to play around with the Venetian blinds and the lights, and it's not working.
No
Yeah.
worries. We can see you fine, Ms. Stevens. Thank you. All right, so we will not be making a request for an expedited transcript. If there, yes.
Oh, I just got a message from Mary Lee Souls asking, let me see, on my text message, give me a second.
Sorry, I do see there are two more people in the waiting room.
Yeah.
So I just let in both of them. One of them was Miss Souls.
Thank you.
So thanks for the heads up on that. Sometimes I'm not looking at the waiting room.
Text messages are really helpful at times.
They definitely are. Okay, so Mr. Gedko, sorry I took a minute to let you in, and Miss Souls as well. I just was asking whether or not anyone thought that they might have a need for an expedited transcript. Our court reporter had that question. We could address it again at the conclusion of the hearing, but if any party does request an expedited transcript, then we would expect that party to pay for the cost of the additional cost for the expedited transcript. Mr. Gedko, at this point, do you believe you'd be looking at requesting an expedited transcript?
At this point, I do not. Thank you.
Okay. Thank you. And Ms. Souls?
No, ma'am. Thank you.
Thank you, Ms. Souls. All right. So if everyone could just very quickly introduce themselves, and if counsel who you're representing, if pro se, just please indicate that you're pro se. We could start. I don't know if everyone is in the same order as I see you on the Zoom meeting, but Mr. Torres, I would ask you to start.
Yeah, Madam Hearing Examiner, I actually see my name is wrong. This is Jeff Wexler on behalf of El Paso Electric, and with me as well as Nancy Burns, the Deputy General Counsel.
Thank you, Mr. Wexler.
I'll change my name. I apologize for that.
Well, I don't know everyone that well yet, so I can be confused in that fashion. All right, thank you.
Madam Hearing Examiner, everybody, good morning. I'm Anastasia Stevens. I'm an attorney for the city of Las Cruces and the, I guess, moving party on the confidentiality request and request for reconsideration. I really appreciate your holding this hearing.
You're welcome. Mr. Herman.
Madam Examiner, Keith Herman with the law firm of Stilsner, Winter, Warburton, Flores, and Dawes on behalf of Doña Ana County.
Thank you. I think Mr. Gedko.
Good morning, Madam Hearing Examiner. My name is Kevin Gedko, and I represent the New Mexico Office of the Attorney General. Thank you.
Thank you. Ms. Souls.
Good morning. My name is Mary Lee Souls. I'm a pro se party in these cases.
Thank you. Mr. Borman.
Thank you. Good morning, Madam Hearing Examiner. My name is Bradford A. Borman, appearing on behalf of Utility Division staff. I'm joined by Mark Tupler, who is going to be our witness in this case.
Thank you very much. All right. Anyone else? All right. So, Ms. Stevens, you are the movant in this matter. So why don't you take about 5 minutes and present your position on this, your motion.
Oh, all right. Thank you, Madam Hearing Examiner. The city filed a motion for reconsideration of the order that was issued on December 17th, I think it was. My notes are bad. Because our response had not been received at that time. The commission's rule in the protective order, it's a protective order, it's a standard protective order, so it is for all intents and purposes has become a de facto commission rule. The protective order specifically lays out the procedures for such a request for confidentiality determination, which the city made at the beginning of December. And one of the steps include the company filing a brief, the requesting party filing a response brief, and then another several days for possible replies. I'm not sure whether, whether a hearing examiner need to wait for those potential replies, but certainly our response was our one chance to brief the legal issues, because the actual request for confidentiality determination is basically a pro forma request. And the reasons that we think that the company should have not done what it did is that and what the company did essentially was to designate 4,300 documents by their count as confidential. And you've seen, Madam Hearing Examiner has seen them, I guess, had the opportunity to look at them in camera. The other parties, most of the other I guess all the other parties in this room, but I know we're on a public Zoom meeting, so I won't say anything. They've had a chance to look, and 4,300 documents it's a lot to claim that they're trade secrets when they're not excruciatingly technical, which these are not. So the questions here really are, first, is the commission going to enforce the terms of its standard protective order, because, which demands that, first of all, in paragraph 6.6 says that parties should avoid over designating documents as confidential unless they are protected by the Inspection of Public Records Act, IPRA. Paragraph C1 explicitly says material may only be designated as confidential if the disclosing party can establish that the material is not in the public domain and is protected by applicable law, including IPRA and the New Mexico Trade Secrets Act. And then the specific process that the city filed its request for confidentiality determination under is paragraph I of the protective order. It's challenges to claims of confidentiality, and it starts with stating that staff or party may at any time challenge a claim by a party owning or holding confidential material that the material is confidential. That's a provision the city filed under. The El Paso Electric, to a certain degree, followed the steps that flow from that section I of the protective order. They submitted the documents to you for in-camera review. They filed a brief. They filed an affidavit, but they did not file a request for hearing. Here we are with a request for hearing. And then before we city filed our again mandatory shall respond within 3 days. Your first order was issued. So the company's response is based in paragraph K. Your order is based in paragraph K. That's a separate and parallel process for handling allegedly confidential material. The second point is that the commission has in several orders, most of them written by hearing examiner Anthony Mazeros, but also one by hearing examiner Carolyn Glick, have gone through a very detailed, thorough, very, extraordinarily thoughtful analysis of questions about confidentiality, both process and substance. And they've basically come down to the conclusion that, as the language of the protective order says itself, the burden of proof is on the party claiming confidentiality. And before a party, in order to use this sort of what's supposed to be an expediting mechanism, the party has to essentially make a good faith determination that each item that they claim is confidential and each portion of each item that they claim is confidential is entitled to that protection under the law. They can't just throw a blanket claim and say, oh, come back and get us, or come back and ask for us. And that's what EP has done in this case. And in one of those cases, the first one in which Anthony Maderos really laid out all the law, he concluded that P&M, Public Service Company of New Mexico, had abused the commission's procedures in the form of order by over designating within confidential information within a single contract. And here we have virtually everything designated. So to deny the city's motion, I guess, would be just a 180-degree turn on what the commission's been doing. And lastly, if we get to if you want us to argue on the actual points that are raised in my response brief, very quickly, El Paso Electric's brief blurs the categories blurs the idea of what is discoverable, what is relevant and or reasonably calculated to lead to discoverable evidence, with the idea of what a protective order is about. Their legal authority is mostly about admissibility of evidence, not about whether it's confidential or not. And to the extent that they claim that the requests were excessive, their answer to that was to refuse to produce the documents and have us challenge the extent of the answers. It wasn't to throw 4,300 pages of 4,300 documents at us and say, here, you go look for it, and when you find something, we'll go spend. It's been like more than a month. It's been a month and a half now, really, since the discovery was more than a month since the discovery was due, and we still don't have a resolution. That's not how this process is supposed to work. And I hope that you will recognize that and not hold the parties responsible for what is EPE's misinterpretation, misuse, not even misinterpretation, but misuse of a very standard process.
All right, thank you, Ms. Stevens. Mr. Wexler.
Yes, Madam Hearing Examiner, thank you. First, we did not file a reply. We don't intend to file a reply. We don't think a reply is necessary. Turning to your order, we thought that it does not need to be reconsidered. It was sensible. It establishes a reasonable and process. In its request for determination, the city hasn't identified a single document it intends to use in this proceeding. It doesn't identify a single document that it claims was wrongly identified as confidential. Instead, it seeks the remarkable, unprecedented relief of asking the hearing examiner to make a confidential determination for all of the pages of documents that have been designated as confidential. So a little bit of background, and EPE takes an open and common sense approach to discovery. We recognize that our customers and ratepayers have an important role to play. We try to be open and as transparent as possible. And that includes spending hundreds and hundreds of hours reviewing and responding to discovery, even in smaller cases such as the current one. Unfortunately, it has been our experience that the city is sometimes overly aggressive and abuses the discovery process. And I think this case presents a good example that the confidentiality process that the city is attempting to misuse, I think illustrates that. They've also propounded over 350 discrete discovery requests, well over what the nature of the case would require, which brings us to the current request for determination. And that request should be denied as premature. And the hearing examiner should take the sensible approach that was illustrated in the order on confidential documents for 3 reasons. And first, in our response, we refer to bedrock principles of discovery that should be applied to the city's request. And in fact, we objected on that basis. And that is that requests such as this, confidential determinations, can't be overly broad or unduly burdensome. But that's exactly what the city's request is here. It asks that EB take hundreds of hours at significant ratepayer expense to develop a separate affidavit testifying to each of the 4,300 pages. Now, I think it's self-explanatory that that's overly broad and problematic, but I think what really drives home that point is that the city asks for all that work to be done without having any purpose. The city has no purpose for asking that the work be done at all, and it hasn't identified any intention to use those documents. And in fact, the vast majority of the documents would be inadmissible anyway, because they're completely irrelevant to the matters presented in this case, which again illustrates that this is unduly burdensome. But the work wouldn't stop there, Madam Hearing Examiner. You would then have to go through each of those 4,300 pages and the affidavit as well, again, wasting many hours to look at documents that will never be used in this proceeding. Which takes me to the second reason, and that is EP took a reasonable approach here to this confidentiality determination. So given those restraints, we explained that each of the documents identified falls into one of 4 categories. The first is confidential settlement negotiations. The second is confidential information submitted in response to an RFP. The third is confidential proprietary information, and the fourth is confidential system information protected by FERC. Now, each of those categories is long established, well recognized by the commission, and this city doesn't seriously argue against any one of those categories. The approach is also supported by the applicable commission regulation, which can be found at 1.2.2.8.b NMAC. And there you can see that the protective order and the commission is authorized to protect classes of documents, which is really exactly what this is. And we also, in our approach, given that the city didn't bother identifying any particular documents, we then took the time to identify an example of each type of those documents and explain that all of the others fall into each of those categories. So given the overly broad nature and lack of purpose identified by the city, I think this approach is more than sufficient. And I want to address one thing that Ms. Stevens raised in her argument about IPRA, and be clear that IPRA applies to public records, but EPE is not a public agency. And so you can see in the intent of the rule, the idea that it really only applies to documents that are filed, because once documents are filed with the commission, then they're public. They should be public. The third reason that I just want to raise this morning is that consistent with your initial order, you should take a common sense approach to this issue. Find that EPE has done sufficient to justify the confidentiality determinations thus far, but that to go further, the city should identify specific documents that either that it wants to use in some fashion in the hearing. And that approach that you took in your order is really justified from 3 sources. It's the spirit of the protective order, as you indicated in paragraph K, and there's other provisions that indicate that that's the intent of the order. I think rules 1.2.2.8, both subsections A and B, and that keys to documents that are actually filed with the commission. And the other source of your authority is just the inherent discretion of the hearing examiner. Remember, the protective order itself was issued by you, and you can determine its applicability. And the approach that you've taken really is reasonable and workable, because it develops an orderly approach. And we can see that it's a workable and orderly approach because in fact, that's what's happened now since you've issued your order. And we've addressed an issue raised by Ms. Souls having to do with confidentiality. And while we haven't reached agreement, the city has identified a manageable set of 20 to 30 specific documents, which EPE is in the process of evaluating. And that's the way the process really is intended to work. As I said, it's reasonable, sensible, it's manageable, and any other ruling would be completely unworkable, create a very bad precedent both here and in future cases. Thank you very much.
Before we go back to you, Ms. Stevens, I'll ask whether any of the other council or parties present wish to comment on these issues.
Yes, ma'am. I'd like to comment if I may. Mary Lee Souls.
Yes, Ms. Souls.
Forgive me, I have very little voice today.
We hear you.
As a pro se party, and therefore as a citizen and basically a member of the public, I would like to strongly advocate in favor of the city's approach to this, which is to make information publicly available that is not required to be maintained under a seal of confidentiality. And while it's true that El Paso Electric is not a governmental entity, they are also not operating in a competitive environment. So the things that for an ordinary business might require confidentiality because of competitive dynamics simply don't apply in the case of El Paso Electric. El Paso Electric wants to portray this as a very small and simple case, and I don't see it that way. The implications associated with this case are far-reaching, and they're broad, and they affect the people of New Mexico for the next 20 years. This is not a simple case. It is a very major piece of determination that's before the commission. Maintaining this amount of documentation under a seal of confidentiality creates a barrier to having the information open and publicly accessible, available to everyone with an interest and a stake in these proceedings. And while there are processes that the company is proposing to get from here to there, as in first determine what you want to use for the testimony or the hearing, these are unnecessary barriers and tremendously burdensome. And I'd ask the hearing examiner to take seriously the city's position, because that would have been my position as well.
Thank you, Ms. Souls.
Thank you.
Anyone else?
Madam Hearing Examiner, this is Brad Borman on behalf of staff. I don't have anything to add.
Thank you. All right. Ms. Stevens, do you want to reply? Make a
Yes.
short reply.
Yeah, first of all, I would take issue with Mr. Wexler saying that the city that doesn't seriously argue against the categories. You've read our brief. We argue that each of the categories that EPE has identified is in reality in the law under all the precedents is much narrower than the company contends. And a reasonable, what they're calling a reasonable approach is something that the protective order that they asked for, they moved for the protective order. They didn't try to come up with a different protective order. They asked for it, they got it. Now they want to not follow it. That's not good practice under in any worldview, but particularly in a case like this, when we, the interveners and staff, are under an insanely and incredibly tight time frame to complete our testimony. They did not file their amended application until November the 14th. The testimony was due until you thankfully suspended that deadline. It was due yesterday, December 21st. That's less than 6 weeks. And the discovery that's at issue in this this matter is just the first set of discovery that the city issued under in this case on these issues. And it was based on EP's original motion filed in late July. We did not have anything about the Hecate contracts until the 14th of November. So I didn't get to even start issuing my discovery till more than 2 weeks after this set was at issue, was issued. And here we are again, more than a month later, and we still haven't got a resolution because the company didn't operate in good faith and make those determinations. The protective order is plain as day that they're supposed to use that privilege of designating as opposed to seeking one by one protection, item by item protection as they go. They have that privilege of identifying in advance, but to enjoy that privilege, they should be held to the expectations of the commission, and that's good faith determination on each document. If they don't want to distribute any of those documents, then they have a different route, which is to object to the relevance or other matter aspects of it. But once they've decided that they're going to produce it, they should be thinking about that. And they put it in the confidential. They put it in the confidential basket, right? Because that's how they gave it to us. Well, then they were supposed to be looking at it and deciding that it was indeed confidential under these standards. So all the claims that, oh, it's an incredible burden to us, that was their burden at the time they did that. And to the extent that they took a shortcut there, that's why we're all here today and the whole procedural schedule is being put into disarray. That's all I have to say.
Thank you, Ms. Stevens. I do have a few questions, and I would start with a couple of questions to you, Ms. Stevens. I understand, is that correct, that currently you've identified a group of documents that you're asking EPE to specifically review for confidentiality? Is that correct?
Yes, ma'am. On an ongoing basis, these requests were made. I'm trying to think when the first one was made. Whether it was certainly before you ruled. I think it was before you ruled. The second one was made just yesterday, and they are based on items that were closer to believing go into our testimony, given that we had our testimony a day away from being filed. And we were, I don't know about staff, the AG, Ms. Souls, we were constrained, and the company knows that, and they're probably laughing all the way to the bank, right? We were constrained by thinking about, do we go through this process of doing a pink colored confidential testimony and a white colored public testimony, or do we pussyfoot around a lot of big issues and wait and pull out those documents for cross-examination or something? And it's not just the doc, and I think it's important to understand it's not just documents, but it's the concepts and the timelines that we are working through and developing by looking at those thousands of documents. So it's not just the use of a document as an attachment that's at issue when you talk about confidentiality determinations. It's zipping our mouths to talk about the topics, the implications in public, and that's what should be of greatest concern of all to the commission. To have the issues and the story fully aired is that compelled silence. It's not absolutely compelled. I admit that we could go through that, pink redacted testimony, pink pages, and all that sort of stuff. But it's difficult. It's time consuming. It's a burden on everybody to have to read even the ones who have access to the confidential material. It's a burden on everybody to have to read it. It's a burden when you get to hearing to have to, go in and out of closed session. That's why the commission has invoked IPRA as a standard of openness. It's because they want the whole process, as Ms. Soul said, to be open. And that's absolutely appropriate because this is a regulated public utility. And guess who's paying for EPE's decisions or non-decisions? If EPE said, oh, we had come in and say, oh, we want to increase the price by $3.50 and we're going to eat it, maybe there wouldn't have been that issue. I'm not saying that wasn't, because there's also a long time delay here. But to the extent that they're asking us, the ratepayers, to cover them for their decisions, and then they don't want you to know what their decisions are. They don't want the world to know what their decisions are. And that's not right.
Well, all right. So you do have, however, the ability to review the documents at the current
Yes.
time. Yes. And
Yeah. And
your
I've asked-
associates as well, correct? Through the
yes,
confidentiality agreements.
Yes, I will say, as it was said in our, I think it was the response, was that the responses were first due the 15th of November. We got something on the 16th. Everything was, lots of things were claimed to be confidential, and they didn't even they didn't dump the whole pile of allegedly confidential stuff on us till a week later. And I personally, for quite a number of days, I was the only one who had access to that. EPE uses a shared, internet kind of, I don't understand the computers, so I couldn't say, but a share file system. And I was the only one. I personally, not my clients, not my experts, not any of the other parties who signed confidentiality agreements. I alone was the one who had access to that for several days, I think up to either the 30th of November or the 1st of December. And that's kind of hearsay because I've been talking to other council and pro se parties, not my own, not asking my own experts to go checking every day whether you've got access.
Right. There is a provision in the protective order, Ms. Stevens, that requires the response brief to also be accompanied by an affidavit. Do you have any comment on that? As I don't see that one was filed.
Yeah, and I thought to mention that in the request for confidentiality determination. I believed that because the affidavit and the was so generic, they picked 5 or 6 documents out of 4,300, and I, on legal grounds, I believe I rebutted each of them. I don't think that an affidavit, it was not, well, let me put it this way, it was not a question of warring experts over, is this a trade secret or is this not a trade secret? And I believe that that is both in civil litigation and at commission cases. That's really the gist of what the affidavit is supposed to address. That's not what's going on here. It's and picking 5 or 6 examples out of 4,300 is not good. As you know, the city itself alerted the company and yourself to the possibility that one of the actually we identified 2, and they used one of those as an example. But when we identified that, we said we think it's probably, some of it is probably confidential, and they did not pick up some of it because the order, the protective order, says it discusses parts of documents, and that's what Mr. Medeiros' opinion in case 18, order in case 18-00158 UT is about, parts. He concluded that P&M had abused the discovery process by designating as confidential some boilerplate within a single contract, not the whole contract. Boilerplate. We were talking about, whatever, 42,500, 4,250 pages out of 4,300 some. That's just not within the intent or spirit. And yes, I have made some requests and they would be ongoing. The third thing, and I don't want to, this might be something for afterwards, but if I may go a little off topic here about the nature of the protective order.
Sure, go ahead.
and going back and forth with EPE, and yes, particularly yesterday's discussions about the request that I had made, I think more than a week ago, about a week ago, for individual confidentiality determinations. There is a hole, an empty spot in the protective order itself, because if I, just a bunch of subparagraphs, creates a process for what I did, which you could do that either on an individual document basis or on a blanket basis when a blanket group of documents was identified. But then the alternative, when you do have something that you specifically want to use, the protective order in paragraph K explicitly says that you shall follow these procedures on the day the testimony is due, which means that you're forced to do the pink pages and the 2 sets of testimony in order to even invoke that provision. Somehow, there is a hole in the process, and my request to the company, and it also talks, the K has provisions that say file versus give notice of, and again, I'm not sure that those have been tested, but there's some unclearness about whether one has the right under the protective order to ask for and trigger this briefing process until the day of the testimony, which I'm sure none of us, especially you, want to have to deal with double sets of everything. I don't. So, when you get to resolution, I hope at the end of this hearing or whatever, we can come up with a solution to that also, because I've been dealing with these protective orders for a number of years now, not as frequently as the people in the P&M cases, I will surely admit, but it really honestly didn't dawn on me till yesterday, looking at again and again, that, oh my Lord, there's really no neat solution to this, and I don't want to do the pink pages.
Well, it is, altogether a burdensome process. And I understand that it is undoubtedly difficult on both sides. I do think that even though the rule allows for classes of documents to be categorized as confidential, it's problematic that we have such a large group of documents that are being asserted to be confidential when they admittedly could not be reviewed by EPE's witness or expert. Excuse me. I'm not going to rule at this time. What I would like to do would be to review the procedural order and the deadlines that we currently have scheduled in this case. And I would ask that EPE and the city go back to the table to discuss this matter, because it's not feasible for me to review 4,300 pages of documents. I do agree that it's problematic that EPE categorized the entire group of documents as confidential without more individual review of those documents. So I do think that's problematic. I am going to grant your request for reconsideration. However, since I don't believe that you've perfected your request because of the failure to file an affidavit with your brief, at this point in time, I'm also not going to grant the request for confidentiality determination. I'd like the parties who are involved in this particular dispute to have another conversation about it. At this point in time, these documents simply are not public records. They are internal documents of EPE. They've been provided to, I believe, everyone who could look at it, who has a confidentiality agreement in the record. And so, although I do also agree that we want to err actually on the side of making information available to the public for the purpose of understanding the actions by a publicly regulated utility. At this point, we're not going to just say, yes, I don't know, City of Las Cruces, you can take these 4,300 documents and put them out there on the web, or whatever your thought might be about how they might be appropriately disseminated if they were considered to be public records. But since they're still in the discovery process, they're not yet public records. They have not yet been filed or otherwise become documents maintained by the Public Regulation Commission. So I'm going to ask the city and EPE to go back to the table to have a conversation to see whether or not this issue can be remedied, short of going through or continuing a process of review by the commission. With respect to the existing deadlines that the parties are confronted with, which would be primarily testimony that would have been due, which I suspended pending at least this hearing, and I think a discussion about what would be appropriate given the discovery issues, because I understand that we have another motion related to redacted documents. And I realize that's not the subject of this hearing, but if I could get a brief summary of where the parties are at with respect to those documents, I'd appreciate it.
Madam Hearing Examiner, I believe Mr. Wexler and I have been exchanging emails, and the company did some supplemental responses, and I'm pretty certain that's been resolved. I won't say 100% because I looked at them sort of in isolation and not in context of how I would use them, but I think that's been resolved. As to the later informal request for individual documents, that's still a work under process, but the company this morning said that one group of them, and I didn't even look which group it was, that they are standing by their confidentiality claims. So I fear that I'm going to have to start this all over again under paragraph K, like this afternoon, which I would rather not have to do for the benefit of all of us, but I don't know how to address that, except that, given the timeframes, I may have to do, and it will still probably, unless we significantly postpone all of the deadlines, including the hearing, that probably won't work prior, if we do this 5-day, 3-day, 5-day, 5-day, 3-day business days, particularly business days with all the holidays we've got coming in here, it's going to put us well into January before we even get a determination. And that is just, I have to remind you, that's just on the city's 7th set, the ones that I sent out before weeks, or more than 2 weeks before the amended application was filed. There are other discovery responses that, to be honest, I haven't hardly had a chance to look at, except for the most desirable, because I've been so busy fighting discovery wars, and it's not a good thing for me, for the company, for the city of Las Cruces, and for the customers that we represent, that we can't get to the basics. And again, it's not just the documents, it's the ability to address ideas, chronologies that arise from all these documents. Because I don't think I'm speaking out of school here to say that the documents are without exception email messages. There's not a lot of there's maybe a few. I think there's a large, there's a FERC agreement or two, but they're basically it's a lot of email messages, and so you use email messages to know what they're thinking about and to have a chronology. So it's not like I would want to use 1,000 of those. It's just to draw from that the story, the narrative, and that's where the biggest impediment lies in the approach that the company's taken by designating everything. They've cut off access to publicly discussing the narrative, and that's sort of the underlying problem. I know I'm going off topic here, but I just wanted to make it clear that as much as we try, we're still going to have that problem that even if we separated out individual documents, we have the storyline, and that's what the public testimony should at least be able to address the storyline without being blacked out, redacted. That's my fear and concern.
Madam Hearing Examiner, can I be heard very briefly? I'm sorry, you're on mute, I think.
She's not showing mute on my side. But we cannot hear you, Judge.
We can't hear you.
All right. Can you hear me now?
Yes.
Yes,
Yes.
Thank you. Go ahead, Mr. Wexler.
Very briefly, on the motion related to the redacted documents, that is fully resolved. The largest group of documents that the city complained about, we pointed out, had already been produced. There was one small group of documents that had been unintentionally redacted through a miscommunication with our paralegal that had to do with when a particular individual went from being an attorney to simply being a staff member. And once we got that straightened out, we did provide that smaller group. Secondly, we're happy to work with the city. We'll continue to do that. We think that's exactly what the process requires. Third, the city is incorrect that those matters can't be heard. It's only the individual documents which are confidential. All of those issues can be fully discussed within the course of a hearing. And fourth, I did want to, since you're keeping this motion live, I wanted to disabuse you of a couple of things that you indicated that I think are in error. And the first is, we did not claim everything to be confidential. There's a very large number of documents that were produced that are not confidential, or it is only those ones that we produced that we thought were confidential. This leads me to the second thing, and that is also you indicated we didn't have time to review those, or the affiant didn't have time to review, and that's also not correct. Those documents have been reviewed. The point that we were trying to make in our briefing is that there's a very large amount of time that goes into crafting and developing an affidavit, and none of that is necessary unless, of course, the city identifies something that is actually relevant and useful for this case. Thank you.
Madam Hearing Examiner, may I ask a question or a request for a ruling here? Mr. Wexler said that it's only the documents, not the information, or not the information. I said we need to be able to discuss the storyline, the narrative. And that is not my understanding of what the protective. This is from. I don't want to violate the protective order in my witness's testimony, and that is not my understanding of what the designation of confidential material involves. It's the information as well as the literal piece of paper document. And if you could clarify that, that would go a tremendous way towards eliminating or narrowing our concerns. But that has always been my understanding of what this is about.
Is that, Mr. Wexler, an accurate representation of what you said with respect to the material contained within the documents as opposed to the documents themselves?
Madam Hearing Examiner, what's actually confidential is the documents themselves. There may be confidential information contained within them. My point is that if subjects are not confidential, this is an issue that I actually just in the last 2 months was briefing and arguing before a special master appointed by the United States Supreme Court. Subjects are not confidential. That being said, if what we're talking about, for example, is specific costs or something like that identified in a document, obviously that particularized information would remain confidential. What I understood Ms. Stevens to be saying is that the overall arc, the general subjects would be prevented from being disclosed to the public, and that I do not think is accurate.
Thank you. And would you say, Mr. Wexler, then that the disputed 4,300 pages or 4,310 pages, I believe, of documents, that some of those have now been identified as not being confidential, or?
Well, there are. I apologize for interrupting. Were you finished?
Have you actually made a determination within that large group of documents as to which ones are actually confidential and which are not?
We have identified a small batch that are not confidential, but those documents, when they were originally identified, fell into one of those categories that we that we have articulated here. Now, what I will say is there are a number of documents that FERC indicates are confidential. So Ms. Stevens, for example, referred to particular emails, and those emails are discussing internal policies having to do with specific facilities or operational issues. FERC considers those kinds of things to be confidential. We are subject to the jurisdiction of FERC. And so if we didn't claim those as confidential in this proceeding, then we would be circumventing the rules of FERC. And because we're subject to more than one jurisdiction, we obviously can't do that.
Okay. Well, what I'm inclined to do is I will give some consideration as to a ruling on these matters, and I will endeavor to issue an order early next week on the matters that we've discussed today. I would, though, also like to discuss the existing deadlines. And what I'm inclined to do is extend all of the deadlines by 1 month. I would like all of the parties to feel that they have had a sufficient period of time to review the appropriate materials and to fully develop the record. So that would make the intervener and direct testimony of staff due on January 21st. Rebuttal testimony then would be due February 6th. We would extend, the optional mediation to the week of, let's see. The week of February 6th. Stipulations would be due February 13th. I will need to double check the hearing schedule and check for availability of court reporters and so on, but I would be looking at the week probably something like March 6th and 7th. And given that, we need to have a final, I think I'm going to hold off on making a determination right now on when briefs will be due. We would be looking at having a final decision in this matter, I believe, by Sorry. May 15th. So we'll be looking at the briefing being due at the end of March, but we'll talk about those. We'll talk about those dates at the hearing.
Understood, Madam Hearing Examiner. The one thing, if I may, that
Yes.
would just remind you that the PPAs themselves have a commercial operation date of June. And so we will need commission approval within that May timeframe, which is within the 6 months provided by the rules. Otherwise, you know, obviously the company believes that these are very favorable PPAs, and if that order were not received by then that energy and capacity would be used to serve Texas customers because they are favorable.
Thank you, Mr. Wexler. We'll keep that in mind. Any other questions about the revised schedule?
Thank you, Madam Hearing Examiner. We appreciate that schedule. There's an issue. Jeff, I'm sorry for having a mental lapse here. Is the information? No, it's I think it's a public document, right? The December 1st next year progress report. That everybody, I think everybody can weigh in. I'm pretty sure that was good. It was granted to it was given to the AG as well as to city as a supplemental. So, Madam Hearing Examiner, I think I'm safe. Scream at me, Jeff, if I'm off base here, because I don't want to do anything wrong.
Yes, Ms. Stevens. So just a second, Mr. Wexler. Is that an issue because we can terminate the YouTube publication of this hearing? It is streaming at the moment.
I don't.
99% sure it's public, right, Jeff?
Yeah, I think Ms. Stevenson is going to talk about just generally where the projects are right now. And we are comfortable with that. We agree that that is not.
So
Thank you.
One of the supplemental discovery responses that the company submitted in the last week or so, they provided a progress report from Next Era, the developer of the two Buena Vista projects, which says that the Buena Vista 2, the 20 megawatt solar only that is dedicated to New Mexico, they were asking for permission. I'm not sure exactly why they need permission, but to put it into service this month, by the end of December 2022. And I just want to make sure that the company is not taking the position that by delaying the by pushing the hearing date back and the final order date back, that opportunity will be lost.
Mr. Wexler?
Yeah, I'm happy to comment on that. That's actually something that we intend to be raising with the parties. It is true that Buena Vista 2 is completed. It looks like it will be completed faster than originally anticipated. And they will be conducting testing in the beginning part of next year to see if it can be energized earlier. And that's then an issue that we'll raise with the parties as to how that works within the context of we do have approval for those PPAs, but we also have the amendments, obviously. So that's something we'll be raising in the near future with the parties.
And the other question I have, Madam Hearing Examiner, is that the city would tremendously appreciate if you kind of lay down in your order some clarification as to this use versus actual documents, because if I've been operating under a misunderstanding, I feel like I want to see the right thing and make sure that I'm doing the right thing.
All right, thank you.
I have draft testimony. I have very close to finished draft testimony that, carefully avoided going there just because it was going to be too hard to do the two versions on the time frame we had, too hard to do the pink version and the non-pink and the white version.
Okay, well, we'll, like I said, I will endeavor to have an order out early next week, and I will look at that issue as well. So I appreciate all of you providing me with your opinions about where this should go, and I do really appreciate the efforts that you're making to work together to resolve these discovery disputes. So thank you for that. Does anyone else have anything to add?
I do have one question, Madam Hearing Examiner.
Yes,
In
Mr. Borman.
regards- Thank you. Your procedural order, basically it directs, in paragraph I, you talk about the parties filing direct testimony, bait stamped on the lower left-hand corner of each page in the following format. And I guess, first of all, I'm not particularly familiar with this, but I could figure out most of it except for the page numbers. I'm not sure if the page numbers should be page 3 of 12 of the particular document, or page 3 of 75 of any part, filing that we have, and should it be inclusive of exhibits?
So, this is a work in progress to see what is going to be most useful in terms of how we can identify and mark documents. I am thinking that within each filing, that would be the total number of pages.
Okay,
And so each document would be numbered, 1 out of 75, using the example that you provided, 2 out of 75.
okay,
For that document, and that would include exhibits which are
okay.
attached to any particular document. So hopefully
right.
to make it easier to review those. And if, this doesn't turn out to be a good method, I'll probably be revisiting in the future. So
I just I want us to be as helpful as possible. I just want to make sure we do it right.
I appreciate it. There are a lot of documents. So
with 2 witnesses, when we file 2 witnesses' testimony, we'll start one for each witness, so that when you end up with an exhibit to introduce a hearing, it'll be 1 to 75. That
correct. So that we'd be looking at page 53 of exhibit 1. But that the whole document is paginated.
something more to learn on. Okay.
Yes, it is. It is a
Further
process.
clarification, Madam Hearing
Yes, Ms.
Examiner.
Souls.
So when I do my filings in PDF form, they include the affirmation and they include the certificate of service. Are those included in the total number of pages?
I mean, the certificate of service really technically is a separate document. I mean, it's filed with each pleading or filing. Either way, I don't think
Okay.
it's very significant.
Thank you for that clarification.
I think the affirmations are definitely part of the document and should be included within the pagination, the certificate of service. Either way.
Very well. Appreciate it.
You are welcome. All right.
I
Yes,
apologize,
Mr.
Madam
Gedko.
Examiner. I got just a tiny bit lost there at one point, because it was going to go back to the city and EP to try to work together on this, but that's on hold given that your commitment to an order early next week, correct? Did I follow correctly, or is
No,
that?
I would like the parties to continue to work towards resolving these issues. I'm going to provide some clarification, hopefully, and make a final decision with respect to the overall issues that have been raised in the motions and responses.
All right, I appreciate that clarification. It was a little bit weavy there for a few minutes. So
No problem, Mr. Gedko. All right, well, I appreciate everyone's participation in this hearing at such short notice, and I hope that everyone has a healthy and happy holiday season. And I'm sure we will be seeing each other soon. Thank you.
Thank you very, very much.
Thank you.
You're welcome.
thank you.